Education and Research here at the American Society of International Law. For those of you who are unfamiliar with ASIL, we are a 108-year-old professional membership association comprised primarily of international lawyers, but as international law touches on more and more different areas of practice that are getting involved. We are a nonprofit, non-advocacy group, so we do not take a stance on particular issues, but we do create educational and information opportunities for folks interested in a wide variety of subjects in international law. We have an interest group program that is the way for our members to get involved in different specific subject areas, and that ranges everything from international business transactions, private international law, international economic law, dispute resolution, to international human rights, international humanitarian law, and then on to things like international environmental law, space law and technology, anything that you can think of that has a substantive element of international law involved. We have members who are interested and are putting events together and practicing in those areas. We also have several interest groups that are built around demographics, including women in international law, minorities in international law, new professionals in international law. So we have a high variety of different events that are built for specific groups and categories of people seeking primarily to get into practice or talking about the realities of practicing as one of those demographic areas, as well as some that are focused on geographic regions of the world too. I did want to mention there are materials about the Society downstairs on the table. Feel free to take any of those or grab any of the ASIL staff that are around. If you have questions about the event, we'd be more than happy to talk to you about the Society involved there. I do want to mention two very important things about tonight's event specifically. First, it is being live streamed, so we do have an audience online as well. For those of you who are online, as the live streaming page says, you can submit questions for during the question and answer time to the events@asil.org website or email address, and I will read those off for the participants when we hit the question and answer time. And then we also are live tweeting the event, and the sheet has information about the different Twitter handles and hashtags that can be used for that. And then second, I'd like to thank our co-sponsors with this, the George Washington University Law School, and the Swiss Embassy here in DC. Both have been wonderful in putting this together, organizing all of this. I usually have to do a lot more work to make an event like this happen. It was really nice to sit back and watch other folks be very professional in this, so we're very thankful for them, and especially to the Swiss Embassy in terms of sponsoring our reception tonight. So after we finish the event, we invite you all to stick around and have a chance to chat and talk about these in a more personal setting with a chance for a reception afterwards. To that end, I'm going to leave it to the conversation and turn things over to our moderator, Sean Murphy, who's a longtime member of the Society, and we're very pleased to have him serving as our moderator tonight.
Thank you very much, Wes. Let me begin by thanking you for being a very important cog in making this event happen. You're very gracious in saying that others did things, but I think the truth is you were quite important in pulling it all together. I am a professor of international law at George Washington University, and I wanted to start this panel by just setting a little bit of a broader context, which is that all of us in the room who have studied international law know that one of the Achilles heels, perhaps the Achilles heel of the system of international law, is the question of enforcement. Bringing about compliance with the rules of international law. And we do have some ways in which enforcement occurs when one thinks about the Security Council, perhaps, or countermeasures between states to bring non-compliant states into compliance. But the reality is there's not a lot of strong enforcement measures that are available. And so, particularly in the past 20 years, I would say one important trend in the entire field of international law is to think about how to promote compliance by states on their own initiative, that's a central way in which we should be thinking about organizing the system. It's all fine and good to write the rules of a treaty, but if you can't have states follow those rules, it's really for naught. So we have seen efforts to bring about different kinds of compliance mechanisms. Obviously, things like the treaty committees that have been created for the major human rights treaties could be pointed to as an example of a monitoring function that's served by a particular body. various ways in which we've had reporting requirements developed in treaty regimes, some very creative mechanisms, such as the compliance procedures established under the Montreal Protocol regarding the depletion of the ozone layer. Tonight's panel is focusing on this issue in the context of international humanitarian law. And as our first speaker will say, this is something that for the past 2 years has been of great interest ICRC in trying to find ways to bring about greater compliance with respect to international humanitarian law. So we're going to hear first from Ambassador Valentin Zellweger, who is the legal advisor of the Swiss Foreign Ministry. He's going to speak to us for 10 or 15 minutes, laying out some of the basics of the initiative that's underway. We're then going to hear from our 3 other panelists, starting with Laura Dickinson, who's a professor of law at University, and then from Chris Harland, who's the relatively new legal advisor to the ICRC here in Washington, D.C., and then last but not least, Max Reddick, who is an attorney advisor at the Office of the Legal Advisor at the U.S. Department of State. I am not going to provide you anything more about their backgrounds because you have a very useful sheet sprinkled around the room that you can refer to, at least for the people who are in the room. But I do want to say that we're keeping the comments here relatively brief because we want to leave a lot of time for questions and comments from those here in the room and also online. So certainly as you're hearing these remarks, think about things you might want to contribute to the conversation because a big part of this is hearing from you. So with that, I will pass the floor to the ambassador.
Well, thank you very much, Sean. Thank you also, Wes, for providing us with this platform to present this initiative. It's great to be back. I was here about 10 years ago. I worked then for the International Criminal Court, and there was a possibility to present this institution here in ASIL. And I also mention it because talking about compliance, that was the one compliance mechanism you didn't mention in your brief introduction. And I would like to start with the ICC because I think it is probably one of the most powerful compliance mechanisms there could be to make IHL work in practice. The aim of the ICC is to provide individual criminal responsibility. And it is also important because it doesn't distinguish between state troops or government troops, official troops, and non-state actors. Those who commit a crime that is defined in the statute, they will be liable for prosecution in the ICC. And I think it's a very powerful compliance mechanism. But of course, Sean, I would agree that this would not be sufficient, and we all know it. Suffices to read the newspapers every day to know that international humanitarian law is not complied with. And that's the aim of the initiative that the Swiss government has started together with the ICRC. You certainly remember that also about 10 years ago, there was a discussion starting with the beginning of the war on terror, whether the Geneva Conventions still give answers to all the challenges that we meet in modern warfare. And there was a discussion about unlawful combatants and all of that. And it's interesting to see today, 10 years later, that this discussion has led to, I think, what we could call a consensus, and I stand to be corrected by others, that on the substance, the Geneva Conventions do meet all the requirements that we have today. But the one single biggest challenge we have is, as you mentioned, is really compliance. There is a comprehensive study that the ICRC submitted to the last International Red Cross conference that took place in 2011, which is entitled Strengthening the Legal Protection for Victims of Armed Conflict. And the ICRC looked at 35 areas that were mentioned in that discussion about the lacunae, so-called lacunae of the Geneva law. And they came up with the conclusion that, in fact, there are only 4 areas that really need to be looked at in international humanitarian law. First, detention, mainly in non-international conflict, then environment and conflict, IDPs, and again, compliance. And they also said that compliance is the one big challenge. In that conference, the ICRC and the Swiss government then got a mandate from the movement, what is called the movement, the Red Cross movement, which is composed of states, the national societies, and the federation. The mandate indicated now come up with a proposal on furthering or strengthening compliance with IHL. And that was the start for us to, together with states, to try to find ways to strengthen compliance with international humanitarian law. For the international lawyers among you, if you imagine the challenge we had to face, you mentioned some treaty mechanisms. Usually, a treaty mechanism or a compliance mechanism is designed at the same time when you formulate the substantive provisions. And again, I use the statute of the International Criminal Court. If you look at the statute, you will have the crimes that are listed in Articles 5 to 8. And then in, I think, Article 112 or something, you have a full provision on a assembly of state parties. So it was designed with one go. You have a whole system that was set up. And that usually is the approach that is taken. It's taken with the cluster munition, with all modern treaties. The challenge we had was that we did not want to touch on the Geneva Conventions, 49. And the problem, if you don't touch on them, because we didn't want to open first, second, it would take years to negotiate, and then you have to wait for all the state parties to ratify. So that we would have gone for decades without having a mechanism. But the problem is that you need to design mechanisms that are applicable to all state parties. Because the one thing you want to avoid is to have the state parties, and the Geneva Convention are nearly universally ratified. You have over 190 states that have ratified them, but not having all of these states involved in the mechanism. So that clearly meant that we had to find a very inclusive approach from the beginning. The whole exercise has to be based on a consensus. And we have to aim at a universal mechanism, because if we leave out groups of states or whole regions, the whole thing will collapse. The legitimacy of any mechanism will only rely on its being accepted universally. And this led us to have a series of meetings among the state parties to come to a common conclusion that the existing mechanisms in IHL do not work. There are mechanisms. It's not that we don't have them. We have them, but they don't work. There is an inquiry procedure. There is a system of so-called protecting powers. And there is the International Humanitarian Fact-Finding Commission, which is foreseen in Article 90 of the first protocol. Now, the inquiry procedure has never been used. The protective power has been used the last time in the 80s. Switzerland was the protecting power for the UK in the Falkland Wars. And the IHFFC, and I say this because the Swiss Foreign Ministry has a secretariat of this August commission. The IHFFC existed for the last 20 years and never had a mandate. So we started by identifying the reasons why these mechanisms do not work. And there are mainly 2 reasons. First, they rely entirely on the consent of the parties. And second, they are standalone mechanisms. I take this especially for the IHFFC. The IHFFC is a free-floating mechanism. It's foreseen in Protocol 1, but nobody knows it. Nobody knows who it is reporting to. If you read the text, it just says it submits a report to both parties. And then what? You have two conflicting parties and they get a report and that's it. So one of the reasons it's not used is the fact that nobody knows where it belongs to. And this is all the more striking that fact-finding has had a resurgence or a renaissance over the last 10 years, which is very striking. If you look at the number of fact-finding commissions that was created by the Security Council or the Human Rights Council, you will see that there is really a need for such commissions. And the striking fact is that the one commission, the only one that really is foreseen in an international treaty that has a treaty base, that's the one that was not used. So one of the reasons they established commissions within the United Nations is because these commissions then responded or reported to be it the Human Rights Council or the Security Council first. Second, they could decide who was a member of that commission, which is not the case with the IHFFC because they have fixed members, 15. So the first round in our deliberations in 2012 came to the conclusion that there were reasons why these mechanisms didn't function and that it's very difficult to address these, so to speak, these weaknesses, except for the IHFFC. It may be that in the future we find other ways to engage them in fact-finding, but the protecting power system clearly doesn't work and the inquiry procedure is too heavy. That was the starting point. We then looked at other treaty mechanisms, and that is where your point comes in. We looked at the human rights treaty mechanisms, but also in the field of environmental treaties. They have very innovative mechanisms. So we looked at them and we thought perhaps we can learn something of these mechanisms. And out of all these discussions, there was an emerging consensus that there are probably three things we will have to look at in further detail. First, that talking about compliance mechanisms, before we go really into addressing compliance, we will first have to establish a body, a platform for the contracting parties. There must be something like a center for all future mechanisms that may then be tied to the center. So you need to fill the vacuum that is there at the heart of the Geneva system. This vacuum, by the way, has led to the fact that the Human Rights Council, which is dealing with human rights, is increasingly addressing IHL issues, IHL-related issues. If you look at the work of the Human Rights Council, they're increasingly dealing with conflict situations, and you cannot look at conflict situations only through the lenses of human rights. You have to deal with IHL issues. And that leads also to, I don't know how you should say that, but to a mixing of the different concepts, because the two concepts are very different. And there is a risk, at least, and I think it could be avoided to a large extent, but it still exists, that a human rights approach to IHL may water down some of the IHL-related standards. So that brought us to the conclusion we need to establish some kind of a forum where we can deal with specific IHL-related issues. We need to have a platform for discussion. Discussion of what? Of country reports on the implementation of the IHL-related obligations of states. The idea would be that countries would, from now on, and that is new, would submit reports on how they implemented their treaty obligations. They could discuss in their country reports best practices. They could discuss also capacity needs they may face in implementing IHL obligations. And we would then, on the basis of all the country reports that we received, establish a generic report about all the issues related to the implementation and application of the Geneva Conventions. And that is the report that will be debated in the plenary meeting of the meeting of states. And it will be the first time that we have a dedicated forum to discuss IHL-related issues. So that will be the first part that was identified, and Chris will further elaborate on that. The second element that was identified was that we need to have a forum to discuss thematic issues related to IHL. If you look today, for example, the challenges facing IHL, new technologies, new actors, etc., there is a very fragmented approach. There are different initiatives ongoing. There is a Copenhagen initiative on detention. There is a Tallinn initiative on cyber warfare. There is a Montreux initiative on private military and security companies. It's a very fragmented approach to addressing issues that pertain to the development of IHL. By having a dedicated forum, that may be a second feature to discuss the challenges that we face. It could also be a discussion of more issues such as sexual violence in armed conflict or other things that are increasingly in need of discussion. And the third feature would be fact-finding. And I mentioned that the International Humanitarian Fact-Finding Commission may serve as a nucleus for a future fact-finding mechanism. The issue is not ripe. We will have to discuss it in the future, but there may be a time in a few years where we come back and see whether there is a possibility to adapt this commission to the current needs. But again, Chris will go into further detail about that. What are the next steps of this initiative? We will have a next conference next year at the end of 2015, and we will have to go back to this conference and report on our efforts. We will have 2 more meetings of states, and perhaps just as a parenthesis, one of the interesting features is that the Geneva Conventions were adopted in 1949. Since 1949, Switzerland, as a depository of the conventions, organized 1 meeting. Since 2011, the last Red Cross conference, we organized 7 meetings. We will organize 2 more, 9 meetings in 4 years. So you had almost no meeting in 60 years, and now 7 or 9 meetings in 4 years. And I think that is also a testimony to the need of an increased discussion of these issues. So we will have 2 more meetings. On that basis, we will then establish a report, the ICRC in Switzerland, which we will submit to the movement, the states, again, the National Societies Federation and the ICRC. And on that basis, we will be able, hope to be able to negotiate a new resolution that may hopefully be adopted in the next Red Cross conference. And if all goes well, we may have the first meeting of states in 2016. So I stop it here, and perhaps we will then have a possibility to go into further detail, but having had your...
Great. Well, thank you very much. You've served up a number of different issues that surround this this initiative, and I think we've tentatively decided to go in alphabetical order, unless that's changed. Would you rather have Chris go first as the sort of co-initiator of the... So Chris, you have the floor.
Thank you very much. Well, I'd like to thank very much the American Society of International Law, George Washington University, and the Swiss Embassy for the invitation to share some of our thoughts on strengthening compliance with IHL and on, of course, this Swiss ICRC initiative, which we're very, very pleased to be a part of. So Ambassador Zellweger has already focused his remarks on the initiative itself, how it came about. I thought what I would like to do is to provide a few remarks on why the ICRC feels it's quite important, and then to go and provide a little bit more detail into some of the functions that Ambassador Zellweger has highlighted. I think if you know a bit about our organization and what we do in the field, you'll know that respect for IHL is at the core of what the International Committee of the Red Cross needs to see around the world, and relates to, it's at the heart really of the ICRC's action. our operational presence in the field, there are of course many other humanitarian organizations doing similar work, is in large part the result of the needs which are created by exactly this, the lack of compliance with IHL by parties to armed conflicts. So our everyday engagement on the ground, in addition to providing protection, especially for the civilian population, but also to people detained in relation to the armed conflict, as well as assistance to civilians and others affected by armed conflict, aims to encourage the parties involved to better comply with this body of rules. So we're not formally a compliance mechanism. I don't think we would call ourselves as such. But if you look at what the work of a delegate does in armed conflict on the front lines, it is frequent discussions with warring parties saying, don't do this, please do that, on a daily basis. In terms of our work in the legal domain, this, of course, started with the drafting in 1864 of what's sometimes called the first Geneva Convention. We mark 150 years of that this year. That's ultimately aimed at ensuring better compliance with IHL for the benefit of civilians and others who suffer in armed conflict, as well as those who participate in armed conflict. Since 1864, numerous IHL treaties and related provisions and other instruments have been adopted by states, and important norms of customary IHL, of course, have crystallized. So many aspects then of IHL, which can sometimes be divided into conduct of hostilities elements and those relating to protection. There have been some discussions, it's been highlighted, whether new norms are needed to better protect people in armed conflict. And while we think there are some areas where the norms themselves could be improved, and for example, we have another project along the lines of Resolution 1 adopted at the last International Conference of Red Cross and Red Crescent Societies, namely related to detention in non-international armed conflict following on the Copenhagen process, which is slightly different. But we're looking for better clarity in some elements relating to detention in non-international armed conflict. And of course, Ambassador Zellweger mentioned as well the other areas that we looked at, environment, IDPs. But it's really, I think, we would probably, as an organization, highlight this lack of compliance as probably the area where there's the biggest need for progress related to IHL. When we talk about compliance as a term, we talk about a range of activities, of course. We sometimes use the term prevention, and people come back and say, you mean preventing war? Is that what, no, we have a different use for the word prevention, and that's preventing violations of IHL once we're in an armed conflict. And that can take many forms. So of course, the adoption of domestic legislation, which implement these obligations, adequate training of armed forces in peacetime as well, the appointment of legal advisors at what's called adequate positions in the armed forces of parties to a conflict, and in peacetime as well as the teaching and dissemination of IHL to the population at large. This continues to be done by states around the world, and of course the ICRC helps out. But as I mentioned, the effectiveness of the mechanisms of compliance in IHL, that's what we're talking about here tonight, and that's something that we've seen that is a big issue in relation to IHL. Already mentioned were the protecting powers systems, so that normally you have state A and state B, which are at war, and many things that you need to do in armed conflict at the very basic level, informing the other side that you've captured a prisoner of war, so that the other side need not worry that the person is maybe dead on the battlefield, for example. The system contemplated having, if A and B are at war, maybe C and D could then talk, and then the information could be communicated that way. Well, as mentioned, that has worked extremely rarely since its incorporation into IHL instruments. The ICRC, in fact, has performed that role in many conflicts around the world, being essentially the go-between between the parties to ensure that the elements of the Geneva Conventions are respected. So if we look then at the conclusions from the mechanisms such as the fact-finding commission, the inquiry procedure, the protecting power system, these mechanisms have never or have rarely been used. They were designed for international armed conflict rather than non-international armed conflict. And the majority of armed conflicts today are, of course, non-international rather than international. So by the nature of requiring an international armed conflict, you leave out many conflicts for these mechanisms, which, as I say, have either never or rarely worked. And we've seen that the compliance mechanisms of other international legal frameworks, notably human rights, but not exclusively, we feel are not an adequate substitute for a dedicated IHL compliance mechanisms. We then looked at a number of functions that could be used by this new structure, institutional framework compliance mechanism. And the three that have been mentioned, of course, include the periodic reporting of states, which has two elements to it as it's currently being discussed. So there would be a meeting, I think the periodicity is yet to be decided upon, of states parties to the Geneva Conventions, which are among, if not the most widely acceded to treaty or treaty set in the world. And states would therefore be invited to come to these meetings on a regular basis. Well, what would the meetings do? Well, one of the elements would be a reporting procedure done by states. So we don't know the years, it could be every 5 years, states would then, after an initial report, report on a number of elements, including the steps that they've taken to comply with the obligations in the Geneva Convention, starting, for example, with adequate legislation and other elements, but probably going a little bit further than that. That's not to say that it would be an article-by-article review of all of the 4 Geneva Conventions and the 3 additional protocols, but would give some measure of an indication of what the states have done to date in terms of their obligations that exist, including in peacetime. Then in addition to that, possibly every 2 years, states would submit more focused reports. And these could be either dedicated to certain themes or devoted to recent developments in state practice, including case law, and specific issues encountered in the implementation of IHL. Whatever the option chosen, these biennial national reports would then be amalgamated into this single non-contextual report, either a generic report or analytical, which would, as mentioned, then be discussed by the meeting of states. The non-contextual nature of a report and the corresponding discussion has been stressed by a number of states. Many states have mentioned, I think in the course of the discussions, that this thematic discussion is useful because, again, as stressed, there is discussion of IHL, looking at the future of IHL developments, but it tends to be scattered in a number of areas. And I think many states have indicated that having a home for those discussions would be particularly useful. It's also been stressed that these specific sessions of meeting of states should be devoted to thematic discussion. So in addition to the reporting procedure, that you have regular thematic discussions. And that there should be a link between this periodic reporting and the thematic discussion. So through the individual reports by states, you could then have, this could generate the thematic discussions. Normally, most states, I think so far, are of the view that the thematic discussions should not aim at legal development, but focus on IHL issues relating to the application and interpretation of the law. Different views have been expressed on policy-related topics, but many participants believe that thematic discussions should also allow for an exchange of views among states on policy positions adopted with regard to the interpretation and application of IHL obligations in practice. Flexibility is an expression that's been emphasized with respect to the format and outcome of thematic discussions. It is, however, widely understood that such discussions would normally involve an interactive panel format with government, but also outside experts as panelists, and that the preparation of outcome documents, at least of a factual report of what took place, would be useful. A third function that was mentioned was fact-finding. That has, as you might imagine, generated widely divergent views in the consultation process thus far. It's hoped that agreement can be reached by states to possibly postpone further examination of this issue for the meeting of states itself once it's established. In this context, it should be noted that the treaties of the IHL adopted since 1929 have had some form of mechanism. This has included, of course, the inquiry procedures, as mentioned, the IHFFC in AP1, and the Protecting Powers system. Normally, and this is a point that I think we would stress, the new IHL compliance system should cover both international and non-international armed conflicts. The question then arises whether and how the system could improve compliance with IHL by non-state actors or non-state parties to non-international armed conflicts. This question is currently on the radar, but will have to be dealt with in the time ahead in the run-up to late 2015, having in mind the sensitivity which it inevitably generates. Participants also recognize that the ICRC should have an important role to play in any new IHL compliance system, with the caveat, of course, that normally our operational role and our standard working modalities should not be affected by any new system created. The discussions held so far have also acknowledged that any new system should not weaken, but on the contrary should be complementary to the International Conference of the Red Cross and Red Crescent movement, which takes place every 4 years, the next one being 2015. I would close with two brief, but in my view, important points, which have also been made by Ambassador Zellweger. The first is that the new IHL compliance system being contemplated will not be legally binding. It will be voluntary in nature. States at this point are not willing to reopen the existing treaties or to adopt new ones for this purpose. A key challenge in the discussions ahead, once the system is established, which we hope will happen, will be how to ensure its effectiveness. And this is thinking about how that can be done is, of course, something that we invite discussion on. The second is that the current Swiss ICRC process provides for a unique chance to improve the effectiveness of IHL that exists today. Efforts in this direction have been made on several occasions in the past few decades, but none bore fruit. Both we and the Swiss government are investing time, effort, and resources in facilitating the current process, which we're very pleased to be a part of. It should be stressed, however, that it is unlikely that a similar undertaking will be attempted in the foreseeable future. So we therefore are really looking forward to a successful conclusion of this process, and it's a high priority for both us and we understand as well our Swiss partners. And with that, I thank you very much.
Thank you, Chris, very much. That was an excellent description of the initiative that both you and the ambassador have just provided to us. So what we're going to do now is shift to reactions to the initiative. And I guess we're going to start with Max Rettig. We're switching our order around as we go.
Our moderator.
I like the head nod signaling what's going on. So Max, why don't you tell us what you think?
Sure. Well, the first two presentations, I think, did a wonderful job of laying out the background of the initiative. And, you know, I think you guys must have been reading off of my notes because a lot of the same points were repeated. But I think I'll spend the bulk of my remarks, which I'll keep fairly brief, focusing on the perspective that the U.S. government has brought to this initiative. I'll talk a little bit about the U.S. government's favored approach, and then I'd like to focus a little bit on challenges, not because the U.S. government is negative on the initiative, quite the opposite, but because there are still important challenges that I think will have to be addressed for the potential for this initiative to be realized fully. And before I dive into my remarks, I will give the standard caveats for any U.S. government speaker. I have have been working closely on this initiative with colleagues from the State Department and the Defense Department, including Tara Jones, who's in the audience. But I am speaking in my personal capacity, so I'll speak about the U.S. government position with which I'm familiar, but these are my views. So I can tell you that from the beginning, the U.S. government has been very actively engaged in this process and supportive. I think we see it as a really important opportunity to offer constructive, practical ideas on ways to improve IHL compliance. And I think that reflects the form of compliance that we have brought to bear to this initiative. It's a form of compliance it's not international criminal law. We have the International Criminal Court. There have been ad hoc tribunals. It's a different emphasis. It's one that's more focused on technical cooperation among states. It's a model that we've seen work pretty effectively in recent years in a variety of initiatives, and it's one that we are hoping that can be replicated through this process. So that's just sort of a framing remark on the way in which we've approached this initiative. I think there are three basic premises that the Swiss government and the ICRC rightly have brought to bear. The first is that in the majority of armed conflicts around the world, IHL is being violated. I think it's fair to say that a lot of progress has been made over the course of the past several decades in improving compliance with IHL, but I don't think anybody in this room would argue with the basic premise that more can and should be done. The second premise is that existing IHL compliance mechanisms essentially haven't served the purposes for which they were originally envisaged. And I think that's true too. We've heard about the protecting power mechanism, which hasn't been invoked since the early 1980s. We've heard about the inquiry procedure, which sadly, for those who would like to see it invoked, never has been. And we've talked about the International Humanitarian Fact-Finding Commission, which also has never been called to exercise a mandate. The third premise is that human rights mechanisms increasingly are being looked to perform sort of a compliance role for international humanitarian law. I think as a factual matter, it's very hard to dispute that. One could take the view that that's not such a bad thing. One could take the opposite view that in fact it's quite detrimental. But I think whether you view it as a positive or a negative, it seems clear that unless there's an alternative mechanism that is devoted to addressing international humanitarian law issues, human rights bodies will continue to, and perhaps even more aggressively, tackle international humanitarian law issues in the future. I'll touch briefly on the principles that the U.S. government has looked to in approaching our kind of this institutional design process, which states and the ICRC and the Swiss government have worked through together. The first is that and this maybe is obvious, but any new form or mechanism has to be effective. I guess what we mean by that is that we need to take a careful look at how we're designing any new mechanism to ensure that it's focused on actually producing better compliance, but by all parties to armed conflict, states and non-state actors. And the focus really is on the use in bello rules. So not the resort to force, but the rules that are applicable to the conduct of hostilities and the protection of war victims. So a new mechanism has to be effective. It can't just be a talk shop. The second is that it has to be based on the consent of states. And I think the reason that we look to consent as one of the foundational principles for our approach is that is what is going to bring the parties to conflict into a room together to talk openly and seriously and substantively about IHL issues. I think it was our judgment that if states are dragged non-consensually into a process, we're less likely to see the kind of engagement that can actually lead to improved compliance. Third, we are states. We have to be concerned about resources, especially in these times. So we talked a lot about the way in which to structure this mechanism recognizing that there are very real world limitations to what states are going to be prepared to do. And one can look to other compliance systems, particularly in the human rights world, which are resource intensive, both in terms of the financial outlay that's required from states, but also resource intensive in terms of the time that is required for states to prepare reports. So we try to strike a balance between something that's going to be effective and something that's not going to be so onerous that you're going to see states essentially dropping out because or showing up and not participating in a serious way because they don't have the resources. And the fourth, and I think maybe final, in some sense the most important principle is that for this mechanism to work, it has to be non-politicized. I think IHL issues, for good reason, elicit a great deal of interest, a great deal of emotion in many cases, I think for the purposes of producing a mechanism that is going to be effective at producing improved compliance, we thought it was important to ensure that the institution is designed in a way to encourage substantive dialogue, not sort of technical exchanges based on good practices, rather than an individualized form of review like you see in other compliance systems like the Universal Periodic Review. So it was sort of through the application of those principles and through robust engagement with other states, the Swiss government, and the ICRC that I think the body really has achieved something approaching consensus at this stage on at least two core functions of a new compliance mechanism, which have already been addressed in some detail and I think very, very well laid out. Periodic meetings, which would happen every year, maybe every 2 years, to be determined. And then reports, and both the reports and the meetings would address not just sort of the baseline issues of compliance, how do states implement their obligations, what kind of training do they do, but hot button issues. I mean, I think that's an important point is that states are coming, in the United States included, are approaching this initiative prepared to talk about difficult issues. So when I say that non-politicization is a bedrock principle, I don't mean we can only talk about things that are easy or things that are non-controversial. I think the point is that states need to be prepared to have a real sort of technical exchange in which they're willing to hear other views, they're willing to engage each other on how states have tackled challenging issues. One of the examples that we come back to on a pretty regular basis when we're trying to explain the way in which we think about the non-politicization of a new mechanism is something that the government of Colombia does. When Colombian security forces are operating in an armed conflict setting, they have one set of rules of engagement on one side of a card. When they're operating in a human rights framework, they flip the card over. It's simple. Maybe one might think that you don't need to have a meeting of states to talk about such a such a simple thing. But I actually think that it's exactly the kind of exchange that needs to be fostered and there's room for in the international system. And so I'll spend just the last maybe minute or 2 minutes, however much I'm allowed, focusing on a couple of the challenges that we see laying before us. I think one is the issue of non-state actors. I think it is no secret that non-state actors are among the greatest offenders, the greatest perpetrators of violations of international humanitarian law. And I think that there's widespread recognition among the states that have participated in the initiative thus far that something has to be done. But I think we all have to admit that we don't quite know what to do. I think there's a recognition that we're not going to invite non-state armed groups to participate in these meetings. So it's something that is, I think, vexing all of us. And we've tried to brainstorm various ways in which we can at least make some effort toward addressing violations by non-state armed groups. But if there are folks in the room who have ideas, I think we would all be all ears. You can imagine how controversial this topic is, but I think you also can appreciate how important it is to try to come up with an answer. On fact-finding, I think this is a very controversial issue. It's one on which the US government, I think, has been clear from the start that non-consensual fact-finding is inimical to the kind of atmosphere that we are trying to foster and that we think would produce improved compliance. So we've been very strong on that, I think, from the start and throughout. That said, we do think that there is potentially room for the International Humanitarian Fact-Finding Commission to play a role of some form that will have to be sorted out, that will have to be consistent with the underlying principles, and that will have to be carefully designed, but a role for them to play, advertising their services. And if states do avail themselves of the services of the Fact-Finding Commission, they think that it would be helpful in promoting compliance in a particular armed conflict, they could report to the body on how they found the experience, and that might be helpful as well, and spurring other states to similarly avail themselves of the Fact-Finding Commission services. I think I would just conclude by coming back to the risk of politicization, and I would make one other point. So, we, I don't think that, I think it's easy to become wrapped up in the issues of the day. It's easy to think that those are the issues that have to be addressed, and that they have to be addressed in a way that, say, human rights bodies would address them, or other mechanisms. But I think, although it is going to be important for this body to address timely topics, it has to be done in a way that states are going to continue to participate, that one state or another is not going to be singled out for non-compliance. And I think I would just close on a sort of a more positive note, which is to say that I think there may be some who would say that that what states have come to thus far, that the proposal that seems to be achieving consensus is too little. But I actually think that we have to appreciate just how much it could accomplish. We've never had, since the advent of the Geneva Conventions, a home for these issues where states can come together and talk about them on a regular basis and engage each other. And I think it really would be an important step forward for us to be able to put together a body that that has reports on a regular basis, meetings on a regular basis, and our hope and our expectation is that that could make a really positive contribution to compliance with international humanitarian law. It won't solve all of our problems, but I think it'll be an important step forward.
Great. Thank you, Max. That was terrific. So I think we're now on to Laura Dickinson finally. And it's perhaps a good segue because all three of the speakers and Max in his final remarks referred to the problem of the non-state actor in all of this. Max talked about, I think, largely in the context of the rebel or insurgent group as one type of non-state actor, but the other way in which they feature is as private security and military personnel assisting governments. And so one question is the responsibility of governments in a situation of armed conflict vis-a-vis contractors that they employ. I raise that in part because if you're looking for the book to read on that issue, Laura is the author of a 2011 book called Outsourcing War and Peace. And I highly recommend that as the book to read if you want to delve into the area. But Laura, you have the floor.
Thank you, Sean. Thank you so much for the invitation to participate in this very, very important panel. This topic and this initiative are so significant and important because changes in the nature of modern conflict are putting tremendous pressure on international humanitarian law, not just with respect to enforcement and compliance, I would argue, but also with respect to normative development. And so some might say that these new developments in the practice of war, from the growing use of military and security contractors to the blurring of the boundaries between counterterrorism and armed conflict, to the growing use of new military technologies, are putting a tremendous strain on both the normative framework for international humanitarian law as well as for compliance. So, for example, with respect to cyber conflict, there are huge issues about when international humanitarian law even applies, and then when it does, how to apply it in this new and emerging context. Other technologies, such as the use of drones, autonomous weapons, biotechnology, also raise some very difficult and similarly vexing questions. And so I think this initiative is important, not merely for its ability to begin to address the compliance issue, but also because it gives space to address these complex normative problems. And so what I'd like to do here is I'd like to look at a recent initiative on a subset of these questions, a joint initiative also of the Swiss government and the ICRC, the Montreux process for establishing principles of IHL as they apply to private military and security contractors, and the accompanying code of conduct for private security contractors that emerged out of that process. And I think that this process in some ways can serve as a kind of model for this broader process. And so I'm going to walk through that process, and I'd like to use a lens to evaluate it. And I'd like to consider 4 factors that I do not think are exhaustive or exclusive, but I think are 4 factors which are important ones to use to measure any such process. And those are, first, normative development; second, participation; third, transparency; and fourth, accountability. And just to summarize at the outset, this joint initiative, the Montreux process and the accompanying code, was designed to address the growing issues that were emerging as the use of contractors by states and in armed conflict began to increase dramatically, particularly during the Iraq and Afghanistan conflicts, but also beyond. And so the process resulted in a series of principles that elaborated on existing international humanitarian law commitments. So it wasn't a treaty that emerged, but an elaboration of principles as they applied to this new set of circumstances and issues. And it spawned a related effort that was led by multiple stakeholders. You mentioned non-state actors. This parallel effort to create a code of conduct was led by governments as well as the industry and civil society as well. So it was very significant, and the code was developed as well as an implementation mechanism for monitoring compliance with the code. So let's turn now to look at these 4 factors as they apply to the Montreux process and the accompanying code and its implementation mechanism. So turning first to normative development, I think that it was quite strong because there was a very specific elaboration of the principles of IHL as they applied to this specific set of concerns and issues that arose from the growing use of private military and security contractors. And so the Montreux document lays out state responsibilities and responsibilities with respect to the contractors themselves. And the responsibilities of states are laid out as to the formation of contracts, the content of the contracts, the management and oversight of the contracts, as well as responsibility, and both in the form of civil and criminal liability. The code of conduct went even further for private military and security contractors. And it really elaborated on the norms as applied to those contractors. It, for example, laid out very detailed rules regarding how the use of force applied with respect to military and security contractors, the treatment of detainees, and the prohibition on torture, clearing up any ambiguity that was lingering in the law about whether private actors were in fact bound. And it also created a commitment on the part of those who signed the code, the firms who signed the code, to actually transform their internal organizational structure to include certain practices like training in IHL principles and so forth. So I think on the normative development front, the Montreux process and the accompanying code were quite strong. It was also flexible. It wasn't a treaty, right? So it was more nimble, and there was a greater capacity to develop these norms in a what we might call a soft law form, or we could see them as interpreting existing treaty commitments. Turning then to participation, if we look at both the Montreux process and the code, participation was reasonably broad. For the states participating, it wasn't a huge number of states. It was 17. So it was a subset to a tiny subset of states parties to the Geneva Conventions, but it was states with a particular interest in and concern with this particular topic. Now that has grown to 50 states who are participating. But I think this point about non-state actors is very important because the process was able to accommodate and include a variety of non-state actors, including experts, representatives from industry, and civil society. In addition, the code was quite broad in its participation. It was drafted in a manner that shared and divided responsibility among multiple stakeholders, industry, civil society, and governments. And not only for the drafting of the code itself, but also the charter for the implementation mechanism. And representation in the code is quite broad, with 708 military companies having signed on. The new implementation mechanism, the participation is a little bit smaller. There are 140 companies that have signed on, 6 governments and 13 civil society members. But I think it's quite significant then that you have a framework that allows for the shared authority of these different groups within the context of the code. The other thing I just want to point out about participation is that in the process of creating the code, there was something done that was quite equivalent to what in domestic law we call notice and comment in the context of administrative procedure. So there was an effort to give outside experts and the general public the opportunity to actually comment on the substantive provisions. And then there was a process for incorporating those comments back into the drafting process. Could there have been more participation? Absolutely. There could have probably been broader participation, particularly of non-Western and Southern countries in the process, and also of NGOs and industry groups as well. Turning to transparency, I would say again, this process was fairly transparent. In the creation of the Montreux document, the notes of meetings of experts were made publicly available, and that was significant. Though in a meeting that was held 5 years after the creation of the principles, states gathered to share their experiences and their practices and to submit not reports exactly, but responses to questionnaires about their implementation of the Montreux Principles, those responses of states were not universally made public. I think this would have been a significant improvement in the Montreux process if they had done so. Now, some states, like the United States, made their reports public voluntarily. Turning finally to accountability. There are lots of different ways to think about accountability, and I'm not going to exhaust them, but I'm going to speak about several aspects of it here. For Montreux, the Montreux process, there has been some follow-up in the form of subsequent meetings of states and not exactly reports, but documents that were prepared by states to establish their commitment to articulate how they were following the principles. And I should note that I took part in a group an academic consortium that produced a so-called shadow report that commented on various states that were going to be coming to this 5-year meeting, 5 years after the Montreux document, the Montreux +5 conference. And a number of GW students helped work on that report as well. The code allows for quite a bit of accountability. Many have criticized the code and the implementation mechanism for not having enough accountability, but I think that it's fairly strong, at least as compared to comparable mechanisms. It basically establishes an independent oversight mechanism that pre-certifies firms as meeting various criteria before they can join. And there is a function for continuing oversight if problems arise. Now, that function was diluted in the final draft of the implementation mechanism. There's also a provision that allows for individual grievances to be brought. Firms who sign on to the code are supposed to have internal grievance processes, and if individuals are not satisfied with that, there is some measure by which they can go to the oversight mechanism for the code, and the Secretariat of the oversight mechanism does have a role in mediating some of that conflict if it arises. So in sum, I think that the Montreux process and the accompanying code, as well as the implementation mechanism, together serve as a potential important model for this new initiative. I think that this broader initiative has great potential for normative development, particularly in these highly challenging and sensitive areas. Particularly such as, how to deal with these new technologies of warfare. And I think that such a process as it is being defined has the capacity to go deeper and also be faster and more nimble than a series of formal treaty-making processes. And if it is located in one place, to create a home for such a process and to create more unity than these fragmented processes that we've seen. I do think it will be important to address participation. If it is done in the way that it's contemplated, there will be broad state participation because the existing treaty regime has such broad participation. But I do think this issue of non-state actors is critical, because non-state actors, whether they are guerrilla groups or contractors who are not only operating on the battlefield, but they're actually developing many of these new technologies. And we're seeing how the state is becoming increasingly intertwined with these non-state actors. So for any compliance mechanism to be effective, there has to be some significant role for these actors, both to help in the normative, to participate in the normative discussion, but also to undertake some obligations in terms of the normative commitments. Transparency will be crucial. I think that making these reports public will be essential. Encouraging shadow reports and so forth will be very, very important in this process. Certainly, by analogy to the Human Rights Committee process, the growing role of civil society groups and shadow reports has spurred the procedures on to better and more careful reporting. And with respect to accountability, I also think that regular state reporting is essential, and that is an aspect of this that will need much further development, because beyond making the reports available, there will be questions about whether any form of liability could attach to a state's statements. And I think that is something that is also very important to explore and discuss. So with that, I will just say that I think this initiative is badly needed. I think it is very important, and I look forward to seeing how it develops.
Well, thank you, Laura, very much for those remarks, which I think really urge us to think outside the box quite a bit as we move forward with an initiative of this type, because contemporary armed conflicts are different in many ways, and the approaches we might have taken 20, 30, 40 years ago probably need to be rethought. One of the issues that comes to my mind that we haven't touched on yet, though, is the emergence of this information age as well, where it's possible to capture images of bad acts occurring in real time through cell phones and other devices, uploading them to the internet and revealing to the world things that are going on. And it's interesting to think about whether there's ways to capture that sort of new technology as a part of the process of compliance and accountability. And I'd be interested to hear what either the panelists or the audience think about that. Okay, I think it's time to move to questions and comments from the floor. Why don't we start here on the side with Ron Bettauer.
Thanks very much. I have no doubt that there's a compliance problem, but I want to play the role of a skeptic here, because I have some serious questions about whether more reports and more meetings is the way to solve that. Maybe particular mechanisms on a voluntary basis dealing with specific areas that states come to, like the Montreux mechanism, or others might flake off things. But in terms of a forum, we have the ICRC. They've always raised compliance issues. I recall being many times in state, they come in and raise compliance issues with us. We have a forum. We have questions raised. I think I wouldn't want to see anything done that degrades the ICRC as the forum to go to for international humanitarian law compliance. Now, you said we haven't had meetings, only one meeting up till whenever it was, recently, 1990. Well, I remember going to 2 years of meetings in the 1970s convened by the Swiss government for the, to draft protocols.
To draft two protocols. That was a codification exercise.
And for the weapons, we went to Montreux. That wasn't the Swiss government?
Well, it may have been.
It was the Swiss government because it was later went to the CCW, to the UN, but it was, ICRC. But the Swiss government convened the protocol meetings and experts meetings before that.
Yeah, absolutely.
And we did a lot of work over those years. And now we have every 4 years meetings of the International Conference of the Red Cross, and we do reports for those meetings. And governments come, and the ICR and the National Red Crosses come and discuss compliance issues. So, I mean, there are many fora, and what I see this as taking away from the scarce time of people to prepare. we already do reports on training. I did them in the 1970s on what, and I've never seen any use put to those reports. So you do a lot more reports, but where do you get? And in terms of not, then compliance with what? Sure, you need to make clear what the law is, but there's such wide disagreements on which norms are applicable in what type of conflict exists, which norms are customary and which aren't, that it seems to me that you're going to have a real issue if you just start discussing compliance and everybody disagrees as to what compliance is with what. Then you get to the non-state actors thing, and we had, I thought, a very real solution to that in Protocol 1, and that's what sunk Protocol 1 in the United States eventually. Because the non-state actor had to give certain make compliance obligations in order to get certain kinds of better treatment, but the U.S. wouldn't have anything to do with it, and that's why we're the exceptionalist. We haven't joined Protocol 1 or 2 after all these years when we should have. So I'm puzzled by the notion that these proposals will bring a solution when we have good mechanisms now, many meetings now, and ways to approach them, and we don't have an appetite in states to do new mandatory rules, which might be needed, but there's no appetite to do it. So
Okay, so we've got the skeptical view very well articulated here. Do any of our panelists wish to say a few words to push back?
Well, shouldn't we collect the skeptics?
Okay,
And have
there's more than one.
And then we just address all the skeptical views.
Okay, why don't we go
guess there are other
to
skeptics.
first to Dira Talati here, and then to the back corner.
Thank you very much. I have two comments, and I think my first comment is would I guess be described as a comment from a skeptic. Looking at the proposals, I wonder if they're really compliance proposals. I mean, they might facilitate compliance, but they're not in themselves compliance creating, right? So if you think about the reporting, for example, you're creating another layer of obligation and really another opportunity then for non-compliance with the duty or the commitment, if it's a non-binding one, to provide reports. But the question is, then what? What happens after the report? So it doesn't really help you with well, it facilitates compliance, but in itself is not a compliance mechanism. So it'll be able to show you where there are gaps, but it doesn't create compliance. I mean, the same with the idea of thematic discussions. There are, as already been said, a number of forums where you can have the discussions, but that's not in itself going to help you with compliance. It might assist you in identifying areas where more work needs to be done, but it's not going to create compliance. It's interesting that the one proposal that could be, and again, this would depend on how it's structured and so on, that could be a real compliance mechanism, and that's the fact-finding, is the one on which is kind of, if I understood you correctly, is kind of being placed on the back burner. So it's something that will be discussed in the future. I mean, that's potentially really a compliance mechanism. That's my first comment. My second comment relates to this idea, which I think I heard from all panelists, or this obsession with, voluntary consent. To some extent, I guess you could say that anything that you establish is going to be, by definition, if it's international law, going to be voluntary. There's going to be consent. I mean, the real question is, at what point do you have consent, right? And so you could have consent at the creation of the mechanism, or you could have consent, especially if you're thinking about the fact finding, after the event on which you're going to be engaging in fact finding. What's interesting is there's a very interesting relationship between acceptability of the mechanism and effectiveness. So if you have the consent at the time of establishing the mechanism, but before the event, it's more likely to be acceptable. It's more likely to be effective, but less likely to be acceptable because the states or the parties have less control over, the events. And so that will also be an interesting issue in the design of the fact-finding mechanism if you were to establish it. Those are my two comments.
We have a third skeptic, at least, I think.
I'll be more neutral, coming from the Red Cross. My name is Christy Edwards. I'm the director of IHL at the American Red Cross. And I guess my question or comment is, a couple of you mentioned the role of national societies as part of this process. And we do quite a few trainings with government agencies, State Department, USAID, DOD, and even private military security firms. And we do them on a regular basis. And we want to be very careful that because our partners at the ICRC do play that compliance role and we have the educational mandate, are there things that national societies can do? And I know that many of the legal advisors and IHL directors in other national societies have very robust IHL education programs. But are there things that we can be doing better to assist with this compliance issue, and maybe do better trainings or engage other partners to make this a better process, and not to reinvent the wheel, because of course we do have the meetings with states every 4 years, the international conventions every 2 years, and so we want to make this the most effective process possible.
Anyone else who would like to chirp in at this point on this general thing, or should we have a round of reactions from up here which might spur some further thinking, Ambassador?
Okay, let me try to address some of the points. I would start with you. You said first we have enough fora to discuss these issues. You mentioned the quadrennial Red Cross conference, and I think that's it. There's another forum that you didn't mention, which is the United Nations General Assembly, which has a biannual resolution on the protocols. Now, you mentioned the United States are not party to the protocols, and therefore, I guess you do not submit reports. Now, the thing is, we do have a problem, and I can prove that we have a problem because we have an increasing number of fora that deal with IHL issues. The Security Council that has thematic debates on IHL issues, protection of civilians in armed conflict, sexual violence in armed conflict, women in armed conflict. I don't think that the Security Council was designed, at least initially, to have thematic debates on IHL. It does it because there is a need for it. And if you allow me to address an August audience of a P5 member, Switzerland is not a member of the Security Council. And therefore, it is a very exclusive debate that you lead in the Security Council. Now, our aim would be to have an open, comprehensive debate integrating everybody, and not only a few 15 members of the United Nations. That is one thing. You have another forum that is dealing increasingly with IHL issues that is not designed to do so, which is the Human Rights Council. The Human Rights Council has gone into these issues because we do not have a dedicated forum. And I think that shows, that highlights the need to create a forum. Now, you say that this will lead to additional work. Well, that may be, but I think if in the end we really establish a forum to discuss IHL-related issues, it may deviate the work that we have to do in other fora and to really dedicate this work in the Assembly of State Parties of the Geneva Convention. So in the end, if we're lucky, we will get out even and do the work that we do in undedicated fora in a dedicated fora. And I think that will be a win-win situation. You then said there are a lot of open issues that will be controversial. Now, if you have controversial issues, you have two options. Either you close your eyes or you open them. And our approach would be to open them and to say, okay, let's debate them. If we have open issues, as you said, what is the applicable line in NIAC and non-international armed conflict? Well, let's discuss it. I don't think that we will get any further if we just close our eyes. You mentioned the customary law a study or a customary law issue. There is a study of the ICRC. We all know that it's controversial, but why not debate it? Why not discuss it? We will not get any further if we just, I don't know how you say that in English, if we just keep everything under the
Under the table,
under the table or under the
the rug, sweep it
the
under
rugs.
the rug.
Yeah, exactly. Keep it under the rugs. Take it out and discuss it. If we want to have an agreement on what it is that we want to observe in times of armed conflict, we have to have an open discussion. And I agree with you. We don't have a dedicated forum today to do that. So why not create it? On various points, unfortunately, I have to say I agree with you. If you take compliance in the strict sense of the word, we are conscious that we're not working on direct compliance mechanisms. But we think that we have to go this way to perhaps one day address more directly compliance issues. And you mentioned fact-finding, which is in fact the only direct compliance mechanism. We take note of the fact that it's not possible to discuss it at this stage. It may be possible to discuss it sometimes in the future. And we are open to that, and we are ready to take this, what you could call a detour, through establishing at least a forum to then continue the discussion about compliance. But in a legal sense, I fully agree with you. I think these were the points that were mentioned.
Chris, do you want
Thank you. Yeah, maybe
to steal back a mic?
Thank you. Thank you. So perhaps just a few comments. One is the ICRC as mechanism. Certainly with parties to the conflict, we have bilateral, confidential discussions that take place very regularly with parties to a conflict. Our understanding from what states have been saying is that there are some things where we want a bit better understanding of the rules that are applicable that exist currently in the Geneva Conventions and the protocols. And a forum like this would allow, as Ambassador Zellweger says, for us to discuss that a little bit more than just bilaterally to each of the parties concerned, and us acting a little bit as a collecting point for what states have to tell us about an applicable rule, for example, in non-international armed conflict. So I think we, states are telling us that it's useful. We think it's also useful to have a place where these things can be discussed beyond just bilateral, confidential discussions that we have with states. And I think some of the questions that you raised, for example, what law applies? When do we know we're in an armed conflict or not? There's a fair bit of debate today about issues such as the scope of the battlefield, how wide does it go, or issues such as what's sometimes called co-belligerency. At what point does your support for another state, which is in a non-international armed conflict, mean that you are now a party? So what acts will actually make you a party? And I think states are actually really wondering about this. Another issue is, for example, at what point, if you are a troop contributing country in a peacekeeping operation, where there's command and control in a certain area and it slips from let's say like a classic peacekeeping operation to then actually engaging in hostilities, where there is command and control, at what point do all of the TCCs or all of the member states of the UN, for example, in a UN context, or NATO in a NATO context, do you become a party? These are questions that states are certainly asking us. We're doing our best to try to work them out ourselves, because we have to know at any given point whether we are in an armed conflict and who is a party. So we do that ourselves, but our understanding is that states also want to have a bit more discussion about that in a forum which as mentioned, is a bit more transparent than what we currently have. So I think we would say I think that a forum like this could be quite useful, both for us and for parties to a conflict. I might perhaps be a little bit less skeptical on the positive effects of self-reporting by states as well. Before coming to Washington, I worked as part of something called the Advisory Service on IHL in the ICRC in a number of contexts around the world. And so we would have, as part of our work, we would have meetings of 10 to 20 states from the region, and states would essentially go through a procedure, completely voluntary. We would help them with it. We would try to understand where there were lacuna in the legislation, in procedures. And just very practically, in some countries, we saw positive developments as a result of this. I'll give 2 examples, but there are a number of them. In one case, again, because of the ICRC's policy, I can't name these states, but in one case, a country observed what another country had done for in the process of missing persons in armed conflict. And it's extremely important, for example, to have something to give family members. Someone has gone missing in relation to an armed conflict that lets them participate in society again, culturally, legally, etc. And seeing what other states had done triggered things which were then very useful, and thousands of people then got access to everything from pension benefits to rights associated with reintegrating into societies where they'd been shunned before because it wasn't clear what had happened, for example, to their husband or son. And we saw positive benefits from that. Another one, for example, was in a case where there were real issues about whether you could bring weapons in hospitals in an armed conflict. Well, we worked with states who gave us examples, which were then used in other places where we think it saved lives. So I just want to say that while I understand a little bit of the skepticism associated with do more reports actually do anything, I think in certain cases they can. And then a lot of it will be down to how it's actually run, how it works. But I think, in my experience anyway, there has been a benefit to state sharing of how they do things practically in armed conflict, which might be helpful.
Can I just ask a follow-up on that, Chris, that gets to the question about the role of the national Red Cross, Red Crescent societies? Is part of that possibility of sharing information, could it come through the national societies rather than just the states themselves? Or are you really thinking about it just in the state context?
Do you mean in this process, in the compliance track resolution?
Absolutely, yeah. Is there a role for the national societies in gathering up the kinds of information you're just talking about and finding a way to share it across borders?
I have to say that my understanding is that a number of these elements are still being discussed. So I don't know what will be the final outcome. At this point, primarily, we're looking at state reports. I thought the idea of shadow reports, whether normally, I think I could imagine that they would inform the debate. Then in some countries, for example, there are very strong links between the national societies and the government. So there's an extremely cooperative approach. And I wouldn't see any reason why you couldn't have national societies working together with the government, for example, to produce reports, which then would be a government report, which would be taken to the body. So I certainly think especially in times of armed conflict, what the national societies do is remarkable. And I think them being a part of the process, assuming that there is state consent for it, I think would certainly help things.
Laura?
So first of all, I'd just like to say I think there's a tremendous need to have a pre-existing established home for these very difficult normative debates. Even if you're not talking about a treaty-making process, when these new issues come up, like how to deal with private military and security contractors or cyber conflict, it takes time to create these initiatives, and they're always lagging behind developments on the ground. And I think that if you have an existing home for dialogue and debate and normative development, I think it can be tremendously valuable and much more nimble, so to speak. And then as to the difficult question of whether more state reporting and all the resources that go into that, I worked at the State Department Bureau of Democracy, Human Rights, and Labor, and I know all about how much work it takes to produce the annual reports on on human rights practices around the world, and Congress seems to have an insatiable appetite for reporting by the State Department, which expends just tremendous resources. Yet, at the same time, I think it's important to not underestimate the value that a reporting process can have. And when we think about compliance, maybe we need to break it down into subcategories. And I think implementation is an important component of compliance. Compliance sometimes means, getting recalcitrant states to do what they wouldn't otherwise do. I'm not talking about that. I'm talking about states that are willing, maybe they're not even aware of the seriousness or the nature of the problem, that might be willing to take steps to act, and a dialogue and a format in state reporting can really catalyze that process. And I think that the Montreux process is really a great example of that. And also by bringing in private security, military and security companies, and civil society groups, the firms really were very much on board with all of it. And, I think that the process of dialogue and discussion of best practices really created the space for real change to happen. So it may not be compliance in the hard sense, but I think that there is a component of compliance that occurs in this context. And then finally, with respect to the reports, they facilitate transparency, they facilitate the involvement of broader actors, because, states, even states that are willing to give information, they're multifaceted entities. In the United States, you got the State Department, Defense Department, you got, these different agencies, sometimes doing different things. And a reporting process for a state helps bring those agencies on board and then provide information which hopefully would be made available to the public that then can foster a broader debate and inclusion for non-state actors and groups.
I'll make only a few very quick points, because I agree strongly with a great deal of what each of my co-panelists have just said. I think it's healthy to have a degree of skepticism. I think that the U.S. government approached this process with a degree of skepticism, and I think that was shared by a lot of states. And I'm sure the Swiss government and the ICRC had their own doubts. But I think what we've seen is states, with the help of the two coordinators, zeroing in on the right kind of reporting, not just reports that will be written and forgotten and that will vanish into a black hole, but the kinds of reporting that's going to spur the identification of issues that need yet more attention. We've always been open to the possibility of something like the Montreux process being born, or sort of the next Montreux process being born out of the kinds of discussions that could potentially take place through the IHL compliance initiative. And so it's true that this is maybe not a pure form of compliance, but the thought has been that this is what's actually needed to focus states on implementation of IHL. Maybe that's the better word to describe what this is all about. It's about implementation rather than focusing attention on instances of non-compliance. And I think the kinds of exchanges that Chris was talking about are exactly the kinds of exchanges that I think would lead to tangible, concrete improvements in the way that states implement IHL and fulfill their obligations. And the last point I'll make is just, I don't think you can overestimate the importance of making sure that participation is as widespread as possible. You need states that are struggling with implementation and compliance issues to be at the table, because otherwise you'll have a group of states that don't participate in armed conflict, or that have more or less a very good track record speaking to each other. And that's good, but that doesn't tackle the real root of the problem.
Okay, well, I've been told that we are just about out of time, but we are having a little reception afterwards, so the conversation can continue on a more informal basis. Let me just conclude by thanking again Wes Rist and the American Society of International Law, Susan Karamanian, the Associate Dean of International and Comparative Law Programs at GW, and also Roland Portman, the legal advisor at the Swiss embassy. They were the triumvirate that sort of put together the troika, maybe I should say, that put together the program. Please join me in thanking them and our panelists.
Very nice to meet you.
Yeah, I hope so.
So another special
Gets the conversation going. That's right. That's right. I mean, there's a lot of interest, but Wes would be the person to ask. Because he did not bring anything up to me, I'm assuming that there may not. Yeah.